King's Nest Interiors and the Director General, Mauritius Revenue Authority.
May it please your lordships,
Yes.
together with my friend Deep.
Good morning, Mr. Sozi. Nice to see you again.
Yes, it's not been long.
No.
So I appear for the appellant with my friend Mr. Deby and my learned friends Philippe Kakouti, Rajesh Ramlal, Senior Counsel, and Afzal appear for the respondents.
Yes. Yes.
Lords, as you would have noticed, the grounds of appeal are at page 1 to 6
Yes.
of the bundle. And straight to the point, it is an appeal for your lordships with regard to leave for application of review. And as it stands, the version of the appellant has been unrebutted. There is no information or affidavit which has been put forward by the respondents. The question is, was the court justified plainly to ignore all the facts and issues which were raised and simply rule that there has been a challenge before the ARC?
Well, as I understand it, what the court said was there is at least the potential for complete relief available to you. Why should you take judicial review until it has been established whether or not that relief is going to be obtained?
Yes. In fact, my lords, we do not agree with that, because what they say is, in fact, at page 100.
Oh, yes. Well, it's a very concise judgment. Yeah.
It is a very concise judgment.
Well, I mean, let's assume that that's what they meant. It may not be what they said. I mean, what's the answer to that?
The answer is simple, because I think we have not ventured into the tax issues. We are simply questioning the decision-making process of the respondents.
Yeah, I quite appreciate that, but it may be the ultimate objective, which is presumably the remission of your liability for VAT, that can be achieved by pursuing the appeal. Therefore, why apply for judicial review when that may be a perfectly satisfactory remedy?
I do not think that we can achieve what we want, what we are here for before your lordships today, if we go to the ARC. Because the ARC is statutory, it's got statutory powers, and it cannot deal with the issues which are being raised today, or which have been raised in the judicial review.
But it can decide that you're not liable for the VAT, can't it?
They will simply question whether we are amenable to VAT or not.
Yeah.
And this is not what we are saying. We are saying that there has been, as my lords, we made reference to a number of cases. I think
No, but surely your ultimate objective is to avoid paying tax, isn't it?
on account of the conduct of the parties.
Well, to avoid paying tax, that's your objective.
Yes, but
And if you can achieve that through the appeal mechanism,
yes,
then you don't need judicial review.
Yes, but what about this whole arrangement, negotiations, which we say?
Well, they may or may not be relevant. I mean, if you're not liable to tax, then none of that matters.
Yes, no, I can understand the point which is put forward, but this, we are venturing into the world of tax. Whereas, and one example which was put forward, we cannot bring in the arena respondents number 2, 3, and 4. With whom?
But why do you want to? I mean, if you can knock out the tax, then the less respondents, the better.
Can we?
There seems
Yes, but the point that my lord is putting to you is, let's approach it this way. Let us assume, let us imagine that it would be possible to transact your appeal within a month, and the ARC said, you're not liable for VAT here at all. All of these esoteric arguments that you wish to present would fall away.
Agreed. Mm-hmm. But if they come to the conclusion that we are per se amenable to VAT, And
Yes, but that's an assumption that we can't really make because you haven't pursued your appeal. You've sought to preempt it by your judicial review application.
Yes, I can get your point, my lord, but let us, for us to put forward that on the basis of case law, which is before your lordships, let's say the case of Preston, which has never been put in doubt. In this case, they say that they have been led to believe that X would happen. This is what we say. They have been, when we look at the affidavits of my clients, your lordships will see that.
Well, I think we've got that point, yeah.
Yeah. So, were we not led to believe that some sort of exemption was agreed? And this has been going on for years.
Yeah.
And it is still going on. And that we were taken to task for something which was agreed upon. There was an exemption, the document E9, which is the Customs Tariff Act, at page 174 of the brief. Your lordships will see that this was agreed upon by a number of parties, that is all the parties, and this agreement has been put to place. 73 containers were imported in Mauritius. Out of these 73, 60 were...
Well, I don't think we need to really get into the detail of it, do we? I mean, this is a matter of principle, really, isn't it?
Can I just ask you something? If the Supreme, did anyone suggest that you should simply adjourn the judicial review proceedings and allow the tax appeal to go ahead and then see whether you needed to have the GAR?
The contrary was suggested. The tax case was suspended.
Yeah, but I'm saying the other way around. I mean, it seems to me there might have been a good case for simply adjourning the judicial review proceedings.
This was
get on with the tax case.
We are facing a judgment, as the lordship says, a very concise judgment. Yeah. So there was no door which was open for us to...
Well, I mean, without preempting anything...
this has never been suggested. So,
and what would your attitude be if it were suggested now?
Well, I believe that we were led into a mechanism which has been stopped for some reason, and this is why we say that there is some problem. This is the reason why. From my instructions, it seems that I don't think that the ARC would be able to say we leave that matter open. The law has been closed by the Supreme Court.
Well, obviously, it would depend on us doing something with the appeal, and obviously it would depend on Mr. Baker's position. But you know, my experience, and perhaps I should reveal that I was junior counsel for the Crown at first instance in the Preston case, where it was accepted. It was accepted that there was an issue which couldn't be dealt with, issue of legitimate expectation, which couldn't be dealt with by the appellate court. Now, in this country, we've sort of moved on because now you can do both judicial review and appeal in front of the upper tribunal, but I don't think you have that mechanism in Mauritius. But there's quite a lot to be said that are sort of the tax issues here, which I haven't yet got my head around, are probably going to be better unravelled by the specialist tribunal than by a non-specialist JR court.
No, of course. It is a specialized tribunal. This is what I've been saying by the respondent. I agree. But these are not the points we were focused on Preston. And we say that this is not offer. You have been led to believe that this will be the case, the procedure. If this is the case, can the Supreme Court intervene? We are at leave stage. Taking the respondent's case, we've got the 2017 case, which is the case of Glencoe, where there it was said that let the case be heard substantively before the judicial review. We are at leave stage. I think that my personal view, my lords, with due respect, I think that their lordships jumped the gun because there was nothing apart from our affidavit, and they did not at all take the points which were...
Well, I think we've got that point, Mr. Susie.
So, at the end of the day, does that not open the door for the appellants at least to have a bite before the Supreme Court on the substantive case? This is what we are suggesting. Of course, I do not propose to go through my written case. This is what...
Well, you can take it, we've read that. Closely.
So this is in a gist what I feel. And going to the ARC would, as it stands now, preclude us, shut the doors to the Supreme Court.
Well, I'll want to ask Mr. Baker about that, but...
Shall I answer?
well, no, I think Mr. Susie may be nearing the end.
The Lords, this is the question, this is my reaction to your questions.
Yes.
Apart from that, of course, whatever has been written in the written case...
Oh, you may take it that,
I'm sure
we have read that very closely. Thank you very much indeed. Mr. Dabby?
Nothing to add.
Thank you very much. Now, Mr. Baker.
I anticipate your question, my lord. It would not preclude the appellant from going to the Supreme Court for judicial review if the matter was heard first before the ARC.
Well, there's a 3-month time limit, we understand.
Yes, but I
you-
am
you're-
instructed to make the concession that
Yeah.
if they were subsequently to apply for judicial review, the government would not take the point that they were out of time. This is actually what happened in the Grove Park case, which the noble Lord Carnworth will remember. There was an application for judicial review rejected by the Supreme Court because the ARC was thought to have jurisdiction. The ARC decided it didn't have jurisdiction. They then went back, started a new judicial review application, and the government did not object on the grounds that the 3 months time limit. And similarly here, I'm instructed to make a similar
That's
statement.
very helpful. Thank you.
Yeah. I'm not certain if there's anything else other than perhaps to respond to Lord Carnworth's point,
Yes.
that the procedure that you suggested, my lord, is exactly what happened in the last of the cases that in the bundle GSTS, JR was started, and by agreement it was
Sorry,
suspended.
which case was that?
It's the
Was that in the bundle?
bundle 20, GSTS pathology.
Yeah.
And if you were to, you can take it from the head note, page 558, 5th to 10th line down. It notes there that in the UK, that exactly what your lordship suggested.
Sorry, where in the head note?
In the head note, 558, it's lines 5 to 10. And you can actually see it in the judgment of Mr. Justice Leggett at page 570, about a third of the way down. They commence, the parties are agreed. There's a good management came from judicial review should not
Sorry, I'm not with you.
appeal.
Which paragraph are you on?
It's
Oh, here we are.
58.
58.
The last two sentences.
Yes,
Yes,
that sounds sensible.
absolutely.
But
I
was
discussed
that suggested before the Supreme Court?
I believe not. Apparently, it's not something that's been done before in Mauritius. I asked my learned friend, Mr. Ramlal, who is, appears for the government in many of these cases. He understands it hasn't been done before, but sees no reason why it couldn't be done in an appropriate case.
Looking at this case, it looks as if leave had been given,
Yes.
which is different from the current case where it
Current
hasn't.
case, the leave has been refused, and so your lordships, I cannot, if you consider that the Supreme Court is correct in refusing the leave, you can't now grant leave and say that it should be stayed. The procedure would be the one I think that Lord Kerr was asking about, which is for them to proceed before the ARC. If they're successful in the question, there is no VAT liability. They've had their case before the specialist tribunal. They've raised the points they want to on the substantive VAT law. If they are unsuccessful and there is a VAT liability, then they will be able to go back to start JR. The government will not take a time point.
And the circumstance that leave has been refused Well, I don't think, no, on reflection, that doesn't make any
Leave
difference.
has been refused on the grounds that they had an alternative remedy.
Yeah.
They've pursued that alternative
You can renew the application for the...
But the alternative, which avoids the time point altogether, would have been to have adjourned the JR application, because then it had been made within time, and it could be looked at again later.
As far as I understand, that's not been the practice before in Mauritius. My learned friend says there's no reason why that may not have been done there. But the appellants pursued their claim as associated.
In any event, my lady has looked at the provision with her custom assiduity, but I haven't. But if the limitation point is in similar terms to our Order 53, there is a dispensing provision. I mean, it doesn't mean, and the circumstance that an application was made timiously would be a very potent factor, I should think, in persuading any court that they should be entitled to renew their application.
It is Order 53. Order 53 is followed exactly, even if the concession was not made by the government that we would take the time point, the court would have the opportunity.
The court would be less than receptive, one would hope.
Well, I hope more better than that. I mean, also, you need not to take the point that the Supreme Court had refused permission. I mean, that's a sort of...
No, they refused leave.
Yes, I mean, you would have to agree neither to take a time point nor to rely on the previous refusal of the Supreme Court.
Well, I think that could only be logical. I mean,
Yeah.
the basis on which you sought the dismissal of the application for leave was that there was an alternative remedy. If the alternative remedy proves not to be efficacious, then the basis of your opposition falls away, doesn't it?
Precisely.
Well, that's logical, but I'm just wondering whether, if I'm a judge faced with this application in a year's or so's time, what I would need to satisfy me that I could effectively set aside the decision of the Supreme Court. I mean, are you in a position to bind all four respondents by your concession?
There is a point that the second, third, and fourth respondents shouldn't be here in any event. But I am instructed to say on behalf of the Mauritian government, I'm seeing an odd. Yes. As I say, this is what has happened previously in another case.
You said I would be familiar with a case. Which was that?
I'm sorry?
You mentioned a case which you said I would be familiar with.
Yes, I thought your lordship would immediately spring to mind, the Grove Park case.
Is it in the...
It was last year here.
I said, no, I
you may
have a
remember.
very good forgetfulness. You were in that, were you?
I was, my lord. I wasn't called upon in that case. That may be why it's not.
Well, I'm afraid it doesn't spring to mind, but anyway, we probably don't need it. I mean, it seems to be common ground between you.
But I'm just explaining that it's actually mentioned in the transcript, and what happened there was a similar situation.
Yes.
Application for judicial review refused, went to the ARC, and in that case, the ARC did hold that it did not have
Yes.
jurisdiction.
And it then came back.
And then came back for a new application for JR, which was not opposed.
I mean,
I wonder, Mr. Baker, in light of the very helpful submissions that you and Mr. Souzier have made, the ground between you seeming to us to have narrowed to an almost vanishingly small point, whether there be any benefit in our rising for 5 minutes, say, to see if an agreed position could be achieved. Yeah.
Well, may I just test that slightly?
Yes.
I would be nervous of an agreed position which allowed the appeal. The Supreme Court has, we say quite correctly...
Well, we're not necessarily suggesting that there be that the appeal be allowed, but one alternative might be, for instance, to adjourn this hearing until the position becomes clear. But I don't put that forward as necessarily the panacea. All that I'm saying is it might be better, rather than requiring us to write a judgment which might inhibit the freedom of action thereafter, that at least one should explore the possibility of an agreed position. Well, I'm very...
raise one more question. I'm not quite clear, Mr. Baker, whether you accept or whether you assert that all the issues they're raising can be dealt with by the ARC.
That's very clear. The ARC
So you
has
accept that there
appellate
are
jurisdiction.
Yeah.
If the ARC confirms a VAT liability, then there are public law issues.
So you accept that there are distinct public law issues.
Absolutely. The question really is simply what comes first.
Yes. Well, I think it would be very helpful.
I'd be to a rather nice little note from the hearing of the ARC where they said, qu'est-ce qui c'est le premier, le poulet ou l'œuf? And it really is the case of, and we say very clearly, they should go to the ARC first. And then possibly appeal from the ARC. And then, if there are still issues, then go back for... there may be no issues.
Can I just float something? I don't know whether it's possible in an order adjourning this appeal, if that's what happened, but a preamble setting out the terms upon which that happened might be useful.
Yeah. Good. Right, we'll rise for 5 minutes.
Thank you.
Where do we stand, Mr. Baker?
Where we stand is the suggestion of preparing a consent order with the following elements. That the current appeal is suspended.
Suspended? I'm not sure that suspended... Well, it stands adjourned, perhaps.
Well, stands adjourned.
Yeah, right.
Stands adjourned. The appellants will then pursue their procedures through the Assessment Review Committee and any appeals that follow from that. If, through those proceedings, the VAT assessment is vacated,
Yes.
then the appeal will be dismissed by consent.
Right.
If, on the other hand, the VAT assessment is upheld, then by consent, the respondents will agree to the appeal being allowed. That will mean that the leave would then be granted and then go back to the Supreme Court.
Right. Right. Good.
I think that's probably the best way of dealing.
Yes. There's no agreement as to costs in the event that the appeal is dismissed.
The suggestion is that the costs should follow the outcome of the case.
Right. Mr. Souzier?
Yes, I agree with that.
Yeah. Anything else?
No, I mean, if that can be put into the form
Oh, yes,
of memorandum.
So that the registrar is fully apprised of the terms and there can't be any dispute about that, that would be very helpful. Could that be done within a week, do you think?
Well, it would be quite a good idea if it could be done today. I'd have thought while you're both all here.
Well, you see, my lord is so much less benevolent than I am.
One of my juniors is probably already on his computer.
Oh, such efficiency.
I thought it was going to give me half an
Well,
hour.
well, can it be transmitted to the registrar, let us say by lunchtime? Would that be feasible? Yeah, good. First rate, well done. I think this is the first case in 9 years in the Supreme Court of the Privy Council where there's been a settlement.
It's the first one I'm part of it.
Good.
Well, I think I can't claim credit for it. My Lord Conmouth was the one whose idea it was. So well done. Thank you very much indeed. Thank you.